Much. We will begin the public meeting. Want to acknowledge the people who will be at the uh, podium to speak to the issue that we have to talk about today. I would like to introduce to you on my left Representative Emil Grieser, who is on the Joint Legislative Committee for State Tribal Relations, as an active member. He is here representing the House of Representatives. And also Betty Price, who is the Executive Director of the State Arts Council. I want to take this opportunity at this time to express my appreciation to Ms. Price for setting this meeting up. We discussed the meeting, and through her office we were able to set the meeting up for the hearing. I also want to extend welcome to Jeff Stam, who is Assistant General Manager for the Indian Arts and Crafts Board from Washington, D.C. Also Kimberly Craven, who is Assistant to Congressman Ben Nighthorse Campbell. I think many of you know Congressman Campbell. We also have Rebecca Cooper with Senator Bourne's office, and Gene Wallace with Mike Sinar's office as well, Senator Bourne and Congressman Sinar. We want to welcome you to this meeting. Let me just set the tone of what we're going to do today. We don't have much time. I'm aware of that. But the purpose of this public meeting is to have an explanation of the Indian Arts and Crafts Act of 1990, which was passed, I think, in 11/29/90, and to also express concerns of Oklahoma citizens to the bill. I had an opportunity to talk with Congressman Nighthorse Campbell on Sunday, and we've discussed this bill at length at another time, so he is aware that there is concern about the bill. But I thought it would be best if we had an opportunity to learn what we need to about the bill. I want to welcome tribal leaders that I see that are here, many individual artists whom I show with throughout the country as well, and museum directors, gallery owners, other people who have an interest in this particular legislation. Let me give you just a brief history of what led to this meeting. I'm aware that there was a public hearing in Santa Fe a couple of years ago to get input from individual artists and tribal leaders regarding the intent of this bill. I quite frankly did not follow through with it, and it came to my attention when several people started calling me recently to interpret the bill and first of all they asked, "What have y'all done?" My response is, "I haven't done anything. They done it up there." So I just kind of passed the buck on to Washington. But I do think it's our responsibility in the state legislature to accommodate you with the information that we have. And for that, I want to also express appreciation to Senator Cullison, who has graciously consented for us to use the Senate chambers for this meeting. And it's because of those concerns that this meeting is being held. And it's my understanding that the bill is basically intended to produce truth in advertising, for one. But the historical complexity of Indian identification in Oklahoma is a vital concern. And I think, and as Congressman Campbell said to me, he said, "We want to give the bill time to work, but if it needs to be changed, he would take the initiative to do that at the proper time." And so that is something we want to think about. Just to give you a format of what is going to happen today, we will have an explanation of the bill by Jeff Stam, and Kimberly Cravens to talk both about the statute and the legislative intent. Then there will be an opportunity for those who have pre-registered to make statements and to pose questions to the people here from Washington, as well as to the representatives of our congressional officers. At that time, at the conclusion of that, there will be an opportunity for response by the people who are here to respond to some of the questions. At that time, we will give you an opportunity to ask specific questions. I thought it would be helpful if we first got an explanation from the people who understand the bill best, so that perhaps they may answer some of the questions we already have in mind in their explanation. But that's the process we choose to use. At the conclusion of the meeting today, we will summarize the questions and the concerns of the bill, and we will send them to our congressional delegation as well as to the authors of the bill. With that, I'm going to ask that as I call your name, that you come forward to make your statements. We do want your statements in writing. We are taping the hearing. At that time, I would ask that you come to the front of the chamber at the majority leader's speaker. That is on. If you will come and address the group, we would appreciate it. We want you to keep your responses to 3 minutes. If you have more to say than that, if you have it in writing, it will be a part of the record. So you may want to pick out those parts that you think are most significant. I do apologize that we don't have more time to do justice to the questions and answers, but as you know, the legislature is in special session, and we will begin our session this afternoon, and we will be using the chamber. Other than that, you will be, for those of you who are here, you will have direct contact with the people who have, I think, helped write the bill, and you can be in contact with those people for more specific questions as we go through. At this time, Representative, would you like to make your comments now? Okay. At this time, we would like to introduce Jeff Stam. I'm assuming I'm pronouncing your name correctly, Mr. Stam. Okay. Who is Assistant General Manager for the Indian Arts and Crafts Board. Mr. Stam, if you would use the mic and give us an explanation of the bill as you interpret it.
Thank you, Senator. Let me say that I hope that when we leave here this morning, there'll be somewhat less anxiety in the state of Oklahoma about this law, because although it does represent something of a change, I don't think it's as fearsome as it's been made out to be. Also, I hope that when we leave, I will have a better insight into what problems you all see about the law. Having said that, I'm going to ask Kimberly Craven to take over and give you some of the background before we get into the specific provisions.
Good morning. Can everybody hear me? I have a tendency to have a small voice, so if you can't hear me, don't hesitate to stop me and ask me to speak up. Thank you for the invitation to be here. I'm really standing in for my boss, Congressman Ben Nighthorse Campbell, who helped sponsor this bill and get it through the United States Congress. I want to keep my remarks brief because I'm really more interested in hearing what you all have to say to us about the law. But I'd like to give you a little bit of background about the Indian Arts and Crafts Act of 1990 and tell you how it came to be. The purpose of the law is really to protect Indian artists from unfair competition by counterfeits. The bill amends two provisions of an already existing act that was passed in 1935 that created and set forth the powers of the Indian Arts and Crafts Board, and also the provisions of 18 U.S.C. 1158 and 1159, which sets forth the criminal and civil penalties for counterfeiting Indian arts and crafts trademarks, and for misrepresenting goods and products as being Indian produced. So really, we haven't reinvented the wheel. We've only added some new spokes to it. While there have been some negative reactions to enactment of this law, the intent of the bill was not to authorize a witch hunt to investigate and prosecute those people not affiliated with a tribe that may be producing American Indian-style art, nor to initiate raids and rampant investigations of galleries by the FBI, as some have expressed their concerns might occur. And to be real honest with you, Oklahoma is the state that really is having the most problems with the law. I contacted Gay Kingman, who's the executive director of the National Congress of American Indian, and inquired as to whether they had received any complaints, and she said no. They had talked about the bill at one of their meetings, but there was not a lot of concern. And I've talked to different tribal representatives around the country, and most of the tribes are very supportive of the bill. A little bit of background. 1985 Commerce Department report to Congress estimated that unmarked imitations of Indian arts and crafts imported into this country was siphoning off 10 to 20% of an estimated $400 to $800 million market of genuine Indian handicrafts produced domestically. Many states, including Alaska, Arizona, California, Colorado, Minnesota, Montana, Nevada, and New Mexico, have reacted to misrepresentation by enacting their own legislation to regulate the sale of Indian arts and crafts. Congress has turned its attention to activities in the domestic market where misrepresentation has occurred by individuals claiming to be members of an Indian tribe. What we really were seeking to do was bring a more equitable and equal application of a federal law to Indian country, so that if you were an Indian in New Mexico, you'd be an Indian in Montana, and instead of getting a kind of a hodgepodge different law in each state. The bill that was the beginning of this law was H.R. 2006. Congressman John Kyle from Arizona introduced that bill on April 17, 1989. And my boss was one of the original co-sponsors, so his name is printed on the original bill. It was referred to two committees in Congress: the Committee on Interior and Insular Affairs, that has jurisdiction over Indian legislation, and also the Committee on the Judiciary, which has jurisdiction over the criminal and civil penalties. We conducted a field hearing in Santa Fe that Congressman Campbell chaired just the day before Indian Art Market in 1989. And I'd like to tell you some of the people that we had testify so that you'll get kind of an idea of what that hearing was about. We had several tribal witnesses that testified, including the chairman of the Hopi tribe, the interim vice chairman of the Navajo Nation, and representative from the 8 Northern Pueblo Council. In addition, we had Mr. Leo Kalik, Vice Chairman of the Indian Arts and Crafts Board, who submitted a written statement in addition to testifying. And he gave us possible definitions for non-handicraft goods and Indian. And we really didn't take on the issue of non-handicraft versus manufactured. We kind of stuck to just amending these already two existing pieces of legislation, pieces of law. We heard from Indian artists who were not enrolled members of tribes, because as the bill was introduced, it was a lot more narrow. The definition of an Indian was limited to members of federally recognized tribes. We heard from Carol Snow, who's a half Mohawk woman, whose father is a Mohawk, whose mother was German, and because of the Iroquois matrilineal society that they have there, and that you get your clan identification from your mother. If you don't have a clan identification, for all intents and purposes, you're not an Iroquois. Although they do have ways of adopting people into their different nations there. She expressed her concern that there be a better definition of an Indian, as did another Pueblo woman who, because of the way the Pueblo societies are made up, was not considered to be a Pueblo, even though her grandmother was a very, very famous Pueblo artist. So we took this under advisement, although the tribal representatives endorsed the definition that we had, although they said that they would consider other ones if there were some considerations taken into account for those people who were Indian but were not enrolled, that they would support those. So there was a lot of debate after we got back to Washington about, who was an Indian, what kind of definition were we going to use, and we tried to get a definition that the Justice Department would support. That was really one of our main concerns, is that as we were doing this, that we enact something that was considered constitutional. And after really pulling teeth, we did get a definition from them that they would support, and that is the definition that was included in the bill. As you probably all know, for the purposes of this act, an Indian is defined as a person who is an enrolled member of a federal or state tribe, and we included state tribes at the insistence of some members of Congress who have state tribes in their states, and those are mostly the East Coast states. Although there were concerns that was not constitutional, because that is more of an identification that is bestowed upon a person based on race, as opposed to having an identity as a political status as an American Indian. And I want to expand upon that point for just a second, and that we passed some technical amendments to different Indian laws this past Congress, and one of the amendments was for the Indian Preference Act. And as that bill was going through, the president said, "I will sign these amendments, but I want to let you know, I'm going on record right now saying that we are not giving services to Indians based on their race. We are giving services to Indians based on their status as members of tribes, based on the government-to-government relationship that has been established." So we were really concerned that extending this provision to state tribes would be unconstitutional. And in fact, there is still that concern, but that's the way this bill has come out. The law did not seek to exclude those unenrolled Indian artists from protection of the act, but instead sought to widen the definition of Indian for the purposes of this act only, by allowing them to be certified as Indian artisans by an Indian tribe. And as you all know, this law has generated great concern in your state, where many people are unable to provide documentation of their tribal ancestry and may have no relationship today with the tribe they descend from. The determination of who is an Indian, though, follows the Supreme Court decision Santa Clara Pueblo versus Martinez, which states that each tribe, as a distinct political community, has the power to define its own tribal membership. And as I said, the definition contained in the act was reached after much discussion with Justice Department officials, House and Senate members, and their staffs. And then we did include the definition of state tribes in who is an Indian tribe. And the law basically does these things. It amends the 1935 Act to allow the Indian Arts and Crafts Board to register government trademarks without charge, and to assign them to tribes and artisans without charge. The board may also receive complaints the goods are being displayed or sold that falsely suggest they are an Indian product or Indian produce, when indeed they are not. The board may then refer complaints of such violations to the FBI for investigation. There are two types of violations, civil and criminal. After reviewing the FBI's investigation, the board may recommend to the Attorney General of the United States that criminal proceedings be undertaken. Also, the board may recommend that the Secretary of the Interior refer the matter to the Attorney General for civil proceedings. The only other party eligible to commence civil action is an Indian tribe on behalf of its members. At one point in time, we had included aggrieved parties as those that would be eligible to bring a civil suit, and that was knocked out in the Senate. The penalties have also been stiffened to make them more consistent with other federal laws on intellectual property. And Jeff has a good analogy about that I'll let him share with you. And so that basically wraps up my presentation. I really am very interested in hearing what you all have to say, and you can be assured that I will take your comments back to Congressman Campbell, and that we will, do what we can to help straighten this matter out in Oklahoma. Thank you.
Such a good background, including a brief summary of the law, that I would like to walk through this somewhat quickly and make a few comments as we go along, and then we can get to your statements and questions. First of all, yes, the law talks about misrepresentation of products, but as Kimberly also mentioned, the law begins with expanding the trademark powers of the Indian Arts and Crafts Board. And although that's not the focus of your attention this morning, I think in the long run that may be one of the most significant parts of this law, because I think it will help the Indian Arts and Crafts Board to help identify genuine products in the market, and therefore provide better promotion and better marketability for people who are producing American Indian arts and handcrafts. As Kimberly said, the basic law, which says that it is unlawful to offer or display for sale or sell any good with or without a government trademark in a manner that falsely suggests it's Indian produced or an Indian product or the product of a particular Indian or Indian tribe or Indian arts and crafts organization resident within the United States. That fundamental provision has been around since 1935, and that's not new. What has changed is indeed the penalties for criminal violation of that law, which is to say intentional violations, have been brought into the modern world comparable to other crimes. I know you've seen a lot in the press focusing on these dollar figures for criminal violations. $250,000 for a first offense by an individual, $1 million for a first offense by a corporation. I mean, that gets my attention too, I can tell you. But looking at comparable crimes, I would guess that a fair number of you folks have a video cassette recorder at home. And if you take a pre-recorded tape, make a copy of it, sell it to one of your friends, you have committed criminal copyright infringement with the same penalties that are in this law for criminal violations of the Indian Arts and Crafts Act. The fact is that criminal cases are hard to prove in commercial crimes. I really will be amazed if there are a lot of criminal prosecutions in my lifetime. Under the original 1935 law, there was never a single criminal prosecution. These things are hard to prove. But in those flagrant and egregious cases that come up, you can be sure the federal government's going to try to bring a criminal prosecution if it warrants. Now, under the 1935 law, there weren't a lot of definitions. And under the 35 law, the penalty was $500, which doesn't make much difference these days. I think one thing that this law has changed is indeed it has made a specific definition of who is an Indian. These things have been kind of loose in the past, certainly in terms of marketing Indian art, and so it's been easy not to face those questions. And indeed, now we're going to have to face them. Not just you, but we have to face them too. I speak as an administrator who has to administer the laws that the Congress passes. You've got a lot of questions, and I can tell you at the beginning, I don't have answers to some questions because it's new to us too, of exactly how all this will shake out. But for instance, the Indian Arts and Crafts Board operates museums. We advise Indian arts and crafts marketing organizations all the time. We're going to face a lot of these questions of what is proper under the law and what isn't. In addition to the definition of strictly an Indian is a member of a federally recognized or state recognized tribe, as Kimberly said, there is an alternative in the law, and that is that a tribe may certify a person as an Indian artisan for the purposes of this act. I can anticipate that some tribes will decide to do that based on whatever criteria they decide on, just as they decide their own membership. And I could also predict that some tribes are not going to take advantage of that and will probably restrict it to their own members. That's a tribal issue. That's something for the tribes to decide. It's not something the federal government is deciding. The law has also made a change in that in addition to criminal penalties, there are now going to be civil penalties. And the difference is that in civil penalties, you only have to have broken the law. The government doesn't have to prove beyond a reasonable doubt that it's intentional. Frankly, given the markets and how things work, I don't think there'll be a lot of cases brought under the civil law either, because the fact of the matter is that most people in this country are law-abiding citizens. And when they understand what the law is, they abide by it. But frankly, I don't see a lot of cases under this law. Certainly, the entire implication of the way the bill is written is that the Indian Arts and Crafts Board is the primary agency responsible for carrying out this law. I say primary because, yes, a criminal case could be brought by any U.S. attorney, anyone in the country. You don't have to ask us first. But it would be kind of unusual if they didn't. And the Indian Arts and Crafts Board is not a police agency. We don't have some force of inspectors that's going to fan out across the country. Frankly, we're swamped just with the fact that the law was passed. We have lots to do, lots to get ready before any kind of enforcement is really meaningful. And specifically, the law provides that the Interior Department has to define such terms as what is an Indian product, as mentioned in the law. Now, because this is an amendment to the Indian Arts and Crafts Board's Act, an Indian product is going to be defined as artwork or crafts. It's not going to apply to pencils or hardware, auto parts, all sorts of things the tribes produce that are products. This is strictly arts and handcrafts. And that'll include sculpture, just about anything you can think of. But the board certainly is not going to be fanning out, looking for violations in all over the place. We certainly will receive complaints if people choose to file complaints. But here again, as a practical matter, we're going to have to sit down with other law enforcement agencies such as the FBI, but attorneys general. We want to consult with the tribes. We're going to have to establish some thresholds of information to establish that a complaint is really worth looking into. As at this moment, I can't tell you what they're going to be because they haven't been worked out yet. But just because somebody calls up on the telephone that says, hey, so-and-so over here is misrepresenting their work, well, that doesn't give me as an administrator much to go on. I mean, if there's a complaint, it's going to have to be pretty specific. I think the certification part of the law, in which a tribe can recognize a non-member for purposes of the Act, is important. It is the Act. I mean, it is the out for people who are not official members. But even there, I'm sure that there are going to be some individuals who cannot meet the standards. People who have been marketing their work as Indian art, who are not going to be able to meet these standards. But to those people, I would only say the law only prohibits misrepresentation. There's nothing to keep you from marketing any product you want to market, as long as you don't claim that it's something it isn't. I don't know what the magic words are going to turn out to be. I don't know whether a court case is going to be necessary, although certainly I hope somewhere down the line later this year or early next year, I don't know how fast these things will work, that we can suggest some kind of language so that if you're a member of, sorry, not a member, if you are, say, a descendant of someone who was a member of the Choctaw tribe, but you're not a member, and let's say the Choctaws are not going to certify you, how can you market your work? Well, I don't know what the answer is going to be in terms of which words work. Can you say that you're of Choctaw descent? Can you say that you're of Choctaw heritage? I don't know, but something like that's going to be within the law, assuming it's the truth. As Senator Haney said at the beginning, this is, in effect, a truth in advertising law. And there's going to be a period now in which things are uncertain for you and uncertain for us in terms of exactly how the definitions work out. But in the meantime, I can tell you it's not going to be the policy of the Indian Arts and Crafts Board to support any criminal prosecution or civil case until after regulations are in place that define all these terms, and that's going to be at least 9 to 12 months, I would say. In the regulation process in the federal government, somebody has to draft up the basic regulations. They then have to go through an elaborate review process within the government, and then they are published in the Federal Register for public comments. You then have a public comment period of 60, 90 days, more depending on how significant the issue is. After that comment period closes, then all the comments have to be analyzed. The regulations may be changed from what they were originally drafted based on all those comments that came in, and then eventually issue the regulations. I mean, this is a long process, folks. It just cannot happen quickly, and I cannot prevent an Indian tribe in the meantime from bringing a case under the civil provisions of this law, because they're certainly entitled to do so if they want to. But I don't see how it would possibly be drafted before we even get to the comment period. I think you're going to find that most of this year is going to be a study period. Now, if some department store or some importer starts doing really crazy things, then yeah, we might go after them. But for the average person, the average business person, the average Indian artist, the average Indian artist and craftsman, there's going to be a transition period while we all get used to this. Rather than go on further, you all have copies of the law in your packet. I think I've given you the essence of it. I would only encourage you, after this even, not only those of you who submit statements for the record or write in statements afterwards, believe me, you can call us in Washington. We do answer the phone. We're happy to talk with anyone who is concerned about this legislation. If I have an answer to your question, I'll answer it. And if I don't, I'll say I don't know what the answer is, but that helps give me a shopping list of things that have to be considered. So I would encourage you, even after we leave here, please do get in touch with the Indian Arts and Crafts Board if you have concerns, if you have questions. We want to answer them, and we want to know what your concerns are. Thanks.
Thank you very much. I've also advised the State Arts Council to stay on top of the regulations when they are posted and are available. It would probably be helpful at that time if we had a similar meeting at the time that those regulations are being presented for your comments. You can write them in, or we perhaps will have a hearing at that time. Let me also suggest to you that when people ask me about what I think of the law, first of all, it's the law. It's the federal law. It's already been passed through Congress. And my responsibility, as I said today, is to bring to you information about what the law is, where it stands today. And for the benefit of those who are here representing the Indian Arts and Crafts Board and Congressman Campbell's office and Senator Bourne and Congressman Sinar, an Indian issue that deals with tribes and membership. I realize that you do not have the time nor the resources perhaps to have as many meetings as you would like to have for input. But you have to also consider when you write Indian legislation that Oklahoma has more tribal governments than any state. We probably have a disproportionate number of artists who live in this state. The complexities are great, and I would simply suggest to you that again, for future use, is to please be in touch with us so that we can work with you to see that the bill is enhanced and does what it's intended to do. Before I go on to the first speaker for statement, let me suggest to you that in the Oklahoma statutes in 1974, there was an Oklahoma Indian Arts and Crafts Sales Act passed in the Oklahoma legislature. There is, in the Oklahoma statutes, a bill basically designed to do what the federal bill is doing, except its penalty clauses is not as stringent, nor are they very specific in terms of tribal membership. And in fact, tribal membership is probably much more restricted in the state statute than it is in the federal statute. So I want you to be aware of that law as well. And there is also a penalty provision within that law. It's not much, but it's there. At this time, I'm going to ask Mavis Doran from Oklahoma City to if you would, yes. And you can stand and address the group. Mavis, yes. Okay. Just pick it up, yes.
I want to take this, I'm Mavis Doring, and a member of the Cherokee Nation of Oklahoma. I want to take this opportunity to express my support for the Indian Arts and Crafts Act of 1990. As many of you are aware, I have been appointed to an advisory board by the Cherokee Nation to study the ramifications of this act, but my comments here today are solely my own and should not be taken as the position of the Cherokee Nation. I support the act because it addresses a significant problem which has existed for several years in the area of Indian art. That is, the problem of non-Indians who represent themselves as Indians solely as a marketing device by which they may sell their work to an unsuspecting public. Any person who wishes to receive a benefit because of their claim of American Indian artist ancestry is required to show that they merit this benefit. Those whose families have tenaciously held on to their ancestral culture in the face of the constant and bitter oppression of the majority should be allowed to reap the rewards of this culture now that its spirit and beauty are finally accepted in our society. Many artists who are not currently registered can comply with the requirements of membership through the accumulation of documentary evidence, and I would encourage those persons to take this step. I do not mean to imply that the artwork produced by non-tribal members is bad art or lacks imagination. Nothing in the act prohibits these non-members from selling their art, nor does the act dictate the style or form that these artists may employ. The act merely prohibits non-Indians from selling their art as Indian-made.
Thank you. We would like to have a copy of your comments, Mavis. If you could give a copy of it to us, we can make copies of them.
Well, no, I have a copy.
Oh, you do? Okay, that's fine. That's just right after 11:30. We'll conclude if you bring it to us. Thank you. The next speaker is Jim Burgess, who is the treasurer for the Oklahoma Indian Arts Council of Oklahoma, located in Oklahoma City.
Again, my name is Jim Burgess. I've been working as an art teacher and an art therapist for the past 10 years. I received my fine arts degree here in Oklahoma and am presently in a Master's of Liberal Studies program with museum emphasis at the University of Oklahoma, studying American Indian art and tribes of the southeastern United States. I am an artist and a member of the Seminole Tribe of Oklahoma. I would like to begin by stating how difficult it is to convey my conscience in means other than painting. I feel the issue we are addressing is purely for economic reasons, with Indian policy again being treated as a legal rather than an ethical matter. I have two questions in regard to this act. First, I believe the question is not art, but who is Indian. I feel this responsibility lies solely with the tribes. I wonder about the validity of the paragraph that allows tribes to go beyond the authority of membership to that of certifying a vocation when they certify an Indian artisan. What clear definition of Indian art can be derived for the consumer from the inconsistencies when each tribe is empowered to implement its own plan of certification? Secondly, am I to infer from the paragraph relating to state tribal recognition authority that Indian art recognized in some states can, under the protection of federal law, be sold in other states? I would like to think that the demand for Indian art is based on heritage, but the distinction of belonging to an elitist group of Indian artists is threatened with diffusion because of possible inconsistencies. It seems the act itself defeats its own purpose. In defining Indian, I was under the impression that the lines had been drawn, but I would like to clarify that the cards I carry do not make me Seminole, but they are required proof. Throughout my lifetime, I have been asked to show these cards as proof of tribal identity. To me, that is certification. Thank you.
Thank you, Jim. The next speaker will be Jeannie King, who's a former creator or curator, Indian Art, Philbrook Museum.
Thank you. Assuming the intention of Public Law 101-644 is to prevent foreign-made and non-Indian-made copies of Indian arts and crafts from the marketplace, I welcome it. However, it seems to me that this act is a reversal of our judicial system, which is innocent until proven guilty. It is ludicrous to place the burden of proof of Indianness on all artisans in this country when we know full well that there are only a small number of individuals and organizations who are misrepresenting themselves. To get to specifics, what does an Indian artist do if his tribe doesn't issue membership cards? Will a letter from his tribe verifying his Indianness suffice? What does an artist do if, as in many cases, his parents and or grandparents never bothered to sign up? How can he expect to get tribal membership? Under such circumstances, what hope does he have of tribal certification? What about all the deceased artists? Must the name of each and every one be submitted to their tribe for certification that they were Indian artisans? More specifically, the Creek Tribal Office says if a person is deceased, he is no longer on the list. However, they also state that if I can provide them with a blood card or a voter registration card or a roll number for a deceased person, they may be able to do research, and they could possibly result in a letter of verification. However, if I am doing this for a deceased artist who has no living family, and I have no record to present to the tribe, do I have any other recourse to obtain the certification or verification? What does a shop or gallery manager do about their current vast stock of arts and crafts? Logic tells us there's no way that they can get certification on each of these artisans. Meanwhile, their source of income and the income of the artisans go down the proverbial drain. It seems apparent that this law is a double-edged sword, just one of many that the Great White Father in Washington has handed the Native American. To close on a more positive note, I have great admiration for the work the Indian Arts and Crafts Board has done since its inception in 1933. However, I do not envy the work that lies ahead in trying to make this a fair and just law. Thank you.
Thank you, Jeannie. For additional clarification, as people called in, what we attempted to do was trying to get people from different disciplines who are involved with art in different capacities to address this group today. Particularly, we have artists who are here. We have people who are concerned in the museum area. We have gallery owners and tribal government leaders to address this group. The next speaker is Vernon Askew, who is the owner of the Choctaw Trading Post in Oklahoma City.
Senator Haney, members of the State Arts Council of Oklahoma, ladies and gentlemen, we at the Choctaw Trading Post do endorse and support the intent of this law as protection for the manufacturing and selling of Indian-made goods. These are the things we want to sell in our stores. We are an outlet for the Indians in Oklahoma, having purchased thousands of dollars of their crafts. We also buy merchandise from all over North America to have a variety of Indian goods that will satisfy our customers. We must rely upon traders and wholesalers who have constant and personal contact with Indian craftspeople to supply us with this merchandise. Where in the chain of merchandising does authentication occur, and in what form does it follow Indian-made goods? With one-of-a-kind high-dollar items, this is not a problem, but with less expensive items that are of similar design and purchased in quantity, this authentication appears to be a problem. As an example of the hundreds of items in our store, I selected the least expensive Indian handmade item, a beaded keychain, Indian made. Let me read our supplier's letter of authentication. This is signed by Alpine Rodman, President, Deer Track Traders, Board of Directors, Indian Art Foundation, President, Indian Arts and Craft Association from Loveland, Colorado. It states, the sheer number of craftsmen involved would make it impossible to maintain records documenting the heritage of each individual. In spite of this bookkeeping impossibility, great care has been taken to buy only American Indian craftsmen. It is because of this care taken to buy only authentic arts and crafts that I can say with considerable confidence that to the best of my knowledge, all of the beadwork which you have purchased from us was made by American Indian craftsmen. I ask you again, where does authentication occur? How detailed must it be, and how does it follow the individual piece of craft work? Will the paperwork bury us under the burden? Do I have to attach a copy of that letter to this key ring? Thank you.
Thank you very much. I say second because he's a former owner of the Choctaw Trading Post, is Chuck Charleston from Oklahoma City.
I don't know about this 3 minutes. Indians can pray 3 minutes. But I want to thank my friend Senator Haney and those responsible for giving me this opportunity to speak. I'm Chuck Charleston, a member of the Choctaw tribe. My tribe gave me a card that I've got in my pocket that says I'm an Indian, but I've been a Choctaw all my life. Before leaving my home to come here, I walked through looking at things that decorate our shelves and walls. Every room has items my wife and I hold very dear. Some of the paintings, prints, baskets, pottery, beadwork, and other collectibles were made by people in this room that I call my friends and whose work I greatly admire. The thought of ever approaching them and questioning their tribal membership would never cross my mind. Now, if my descendants someday decide to sell a part of my collection, they might be subject to fine or prison because I failed to have written proof that the artist was an Indian. What do we do about beadwork that has been in existence 60 years or more? Do we insult all of our ancestors' work by saying, no, you are not an artist like Willard Stone, has no card? I personally know many of you, and I have had the privilege of buying your work. Many I have sold supplies to in the past years. Several of you are married to non-Indian people. Can all craftspeople truly say that they have never received any help from non-Indian family members in their work? How pure does Indian crafts have to be? I have no desire to discredit any work done by any Indian artist or craftsperson. Without your beautiful creations to adorn our bodies and our homes, this would be a dismal place to live. I applaud your work and wish you much success. But I don't approve of one group of Indians trying to hurt or discredit another. Government intervention has been a way of life among our people. For us to ask for more is unbelievable. Most all craftspeople I know depend on others to sell their work. For instance, a good silversmith does not have time to sell and at the same time do his work. To jeopardize the sales in museums, art galleries, and with other entrepreneurs across this nation, is biting the hand that feeds the Indian craftspeople. I am afraid that the people who pour millions of dollars into the Indian people's pockets will decide it's safer to sell other products. I hope this law or amendment was written to give an artist with a card, was not written to give an artist with a card an advantage over his fellow Indian artist, that through no fault of his own, his family failed to get on government rolls. I've now been retired and out of business for over 2 years. My wife of 47 years and I started in business here in Oklahoma City some 30 years ago. In the past years, we have put hundreds of thousands of dollars in Indian craftspeople's pockets.
You have 5 seconds.
I thank the great Creator that no one, not in any time, have I ever had to say to my Indian brother or sister, "Show me your card." Thank you very much.
The next speaker is John McClure, who is an artist from Oklahoma City.
I start by saying I salute the efforts of the State Arts Council of Oklahoma, especially that of Betty.
You need to pick up your mic there, please.
I start by saying that I salute the efforts of the State Arts Council of Oklahoma, especially that of Betty Price, Senator Kelly Haney, for setting up this forum, and for our distinguished guests visiting here. Thank you for your ongoing efforts to support and promote Oklahoma artisans. When I first read my copy of the Indian Arts Act of 1990, and then became aware of its instant impact in shutting down Indian museums, gift shops, I was devastated. Not because of its ability to eliminate counterfeit work, I applaud that fact, but because of the unintentional but real effect that it would have on removing from the marketplace those who are not misrepresenting themselves, both non-Indian artists and Indian artists who cannot prove their tribal status. The movement underway by many artists, of which I'm one, to portray the Native American in a more favorable light, which is both proper and historically accurate. A current example of the movement can be found in the Dances by Wolves movie. Why should this movement be hindered just because the artist cannot doctrine his tribal membership? Granted, the film mentioned will not suffer at the box office just because the producers are not certified Indian artisans, but in other markets and with other medias, artists like myself who have been just as conscientious in their portrayal of the Indian will suffer substantially as they attempt to show their work without this certification. But rather than looking at this situation in a negative manner, I would like to challenge the Indian tribes of this state and as well as other tribes throughout the U.S. to recognize this as a rare opportunity to balance the scales, to demonstrate to the world their inherent sense of justice and fairness that have always been part of the Native American spirit. Here's your chance to refuse to punish an Indian just because of his forefathers were strong-willed and refused to be put on the rolls and be put in a white man's camp. Here's your chance to reward Indian artists who portray the Indians in a positive manner, accurately and properly, whether they themselves are 100% Indian, 50, 1, or 0. I urge each tribe to act quickly, set up your committee and requirements, and start certifying these Indian artists. This leads me to several questions I have on certifying. In my case, even though I have Choctaw lineage, I recently have done work for a Cherokee company. Who do I get certified through? The Choctaw, or can this, and I've been recommended as a Cherokee artisan from this company. Will certified artisans have the same privilege as tribal member artists? Namely, can their works be shown in Native American Indian galleries and museums? Can they participate in Native American Indian competitions? In conclusion, if I may be so bold as to presume to speak for all Indian artists who portray the Indian favorably, our hands are tied until we're certified. Thank you very much.
Thank you, John. The next speaker is George Moran, who's the owner of Indian City in Anadarko.
I'm George Moran from Anadarko, Oklahoma. And there are several Indian stores and Indian businesses located in the Anadarko area. And my great concern, along with the Choctaw Trading Company, Philbrook, and other outlets throughout the state, are traders that come in and buy a large amount of Indian jewelry at one time from New Mexico, Arizona area. Now, as far as we're concerned, we've been doing business with these traders for approximately 20 to 30 years, some of them. And we accept the Navajo and Nahopi jewelry as Indian-made jewelry. Now, our question is, how will this be identified, or are we to discontinue buying from traders and start buying from craftspeople? Some of the answers that we had question to have already been answered by the explanation prior to the session. But our greatest concern is, how will the different items that you buy in large quantity be identified? And the way I understood you earlier, you stated that the individual headhunter had been removed from your bill, and it's just tribal. I think that will assist quite a bit right there. And that's all I have.
Thank you, Ms. Moran. The next speaker is Nathan Hart, who is the Executive Director of the Oklahoma Indian Affairs Commission.
Thank you, Senator Haney and Ms. Price, for sponsoring this forum today, and thank you for the opportunity to speak. I'm Nathan Hart. I am the current Executive Director of the Oklahoma Indian Affairs Commission. I am Cheyenne, and I am an enrolled member of the Cheyenne and Arapaho tribes of Oklahoma. I am supportive of the bill's intent, however, I feel several issues are left unresolved. I interpret the Arts and Crafts Act of 1990 as a law designed to protect buyers from misrepresentation of the sale of Indian-produced arts and crafts, and to further improve the economic status of American Indians. The most prevailing issue surfacing at this time is the certification of individuals as Indian artists. Indian tribes have the current responsibility of issuing tribal membership to qualifying individuals. However, this criteria for enrollment varies from tribe to tribe. I have two questions regarding enrollment. First, what is the current responsibility of an Indian tribe to issue proof of tribal membership to Indian artists for purposes of obtaining trademarks from the Arts and Crafts Board? And second, with the provisions that tribes can certify individuals as Indian artists, even though they are not otherwise members of the tribe, will a process of certification be established to develop a uniform procedures for certification from tribe to tribe? I heard an answer to this earlier this morning, and the answer was no. That raises several additional questions for me. Other federal programs have minority business set-asides to improve the economic well-being of an economically disadvantaged person. There are Indian preference laws which currently exist. How will the certification process outlined in this act affect the certifications of being an Indian with other federal agencies and federal programs? In addition to the issues of certification, other legal issues arise which require immediate attention as well. Now that the Indian Arts and Crafts Board is authorized to register trademarks to tribes and artists free of charge, what happens when these trademarks expire? How will the Indian Arts and Crafts Board assist tribes and artists obtaining registration for continued use from the Trademark Patent Office? Will the board notify artists of the expiration of the trademarks? Who will cover any re-registration fees? The initial trademark is free of charge. Are there going to be any appropriations to cover the re-registration fees when these trademarks expire? I have two recommendations. They are that the board consult with tribal leaders, Indian artists, and legal personnel to, first off, establish a uniform process of certifying individuals as Indian artists, and second, to clarify the legal questions of the trademarks. Thank you very much.
Thank you, Mr. Hart. The next speaker is Jeannie Roax, who's an artist from Oktaha.
I want to thank the State Arts Council for setting this up. We have, the reason that some of us have panicked, I'd like to explain, is because we have had some newspaper articles the day after the bill was signed, and they were very threatening. I've left you copies of those. I had written a letter not long ago and had addressed it to Senator Boren, but I didn't mail it, and maybe it was because I was meant to read it today. It goes, I am an artist of Cherokee ancestry. My mother is Allie Stone Walker, Willard Stone's sister. I feel the new law has attacked me in many ways. It is denying me my freedom of expression, denying me the pursuit of my chosen career, denying me of my heritage. And especially, it is formally saying that my family, my mother, father, aunts, uncles, grandfathers, and grandmothers were all frauds, that they illegally gave me something that the United States government had confiscated from them long ago, their identities. Both my mother and my father are descended from two of the many Indian families who refused the mark of the government. The legacy I received from my ancestors was not denial of my heritage, but distrust of government aid. I almost have to thank this new bill for truly opening my eyes. I now have a better understanding of what my people gave to me. They gave me independence. I am fighting this bill not because I want to be a member of a federal or state recognized tribe or band, nor do I necessarily feel the need to be recognized as an artisan by such an entity. I am fighting for my right to truthfully identify myself without the threat of fine or suit. Please read and listen with your heart to the words that Willard Stone spoke in the 1960s. Quote, I try to portray the Indian point of view, that their main drawback is they've been wards of the government. I think the Indian should stand on his own for his own sake and get his self-respect back. Being a ward of the government just naturally makes you think you are entirely dependent on somebody else. The Indian used to be self-sufficient in everything. Then he sort of lost that respect. You get your welfare handed to you, so you have no initiative. You don't care, unquote. I wish you could hear the pain in his voice when he spoke these prophetic words. Please reread your history and understand how Willard and I are two of the lucky ones. We had, until now, been protected from the care of Big Brother.
Thank you, Janie. The next speaker is Leilani Stone from Locust Grove.
I'm Leilani Fuller Stone, and I want to thank the State Arts Council for setting this meeting up today. The Indian, as this bill defines it, was only a small part of a magnificent race of principal peoples that lived within these boundaries that are now called the United States of America. The Dawes Commission has been factually documented as being incomplete and inaccurate, yet this is what the 5 civilized tribes of Oklahoma tribal membership is based upon. My questions are simple, and I think most everyone can follow them. How can such a poorly written, completely discriminatory, and totally unconstitutional bill have ever passed and be put into law? This bill must be repealed. We do not care about the intent. We care about the actuality. We want to know what steps we must take to put an end to this bill and once and for all let the Indian population of the United States be at peace. Why was not Oklahoma, the second largest state in the Union in regards to Indian population, not contacted during the making of this bill? What does the phrase "and for other purposes" mean, and why is it used so frequently in this bill? The American Civil Liberties Handbook gives 23 definitions of Indian. The BIA gives several different other definitions of Indian. How does the United States government have the audacity to interfere with internal tribal affairs again? What about the 80 to 100 different tribes that were simply dropped during the Indian Reorganization Act of the 30s? What about their heritage? What about or do we simply ignore it? Do we erase it from their memories and from their hearts? What about the people who have CDIB cards but do not have tribal memberships? Evidently, the people who have written this bill are not familiar with all the tribes and their internal workings. What about the full-blood Indians who continue to speak only their tribal tongue that do not have a card? Are we to lead our unregistered full-bloods into investigation and prosecution by the FBI and Attorney General? How can a tribal Indian artist that also happens to be a congressman have legally authored a bill such as this? He definitely has a vested interest in the outcome. In view of these questions, I would like to offer the following words from a speech made by a famous member of our Indian Brotherhood. He's a very intelligent man, a man with foresight. Let these words be used today in this situation and see if they do not still ring true. In view of these questions of overwhelming importance, we have met together in solemn council tonight. Nor should we here debate whether we have been wronged or injured, but by what measures we should avenge ourselves. For our uncompassionate oppressors have long since planned out these proceedings, and are not about to make, but have made, and are still making attacks upon our race, who have as yet come to no resolution. Nor are we uneducated as to what steps and by what gradual advances the whites break in upon us. They show themselves less strong because you are hardened. The whites are already a match for us, tribes united, and too strong for any one tribe to resist alone. Shall it be said of our race that we knew not how to remove ourselves from the 3 most dreadful calamities? Foolishness, inactivity, and cowardice? But what needs to speak for the past? It speaks for itself. Where are the Narragansetts, the Mohicans, and many other once more powerful tribes?
You have 5 seconds.
Thank you. Then, my brother, hasten to the assistance of our common cause, as by our union, by blood, you are bound. Spoken in 1768 by Chief Tecumseh.
Thank you. The next speaker is Ron English. Ron is an artist from Anadarko.
Senator, Betty, my concerns here are that up north I represent the Northern Indian. I've talked to several of the northern people from Montana, South Dakota, Minnesota, and North Dakota. We have no problem with this law. In fact, we fully support it. The problem is not here, it's eastern Oklahoma. The census, if you haven't by now, if you're not an enrolled member, then you aren't even concerned about your tribe. You weren't concerned over your Indian kids' the welfare of the elder. The government, we are wards whether we like it or not. The law is passed. This country is founded on law. You got to learn to live with it. Not only is law passed, but laws are passed for laws. It's simple. They stated here, some of y'all can go back to your tribes, and they can make you an Indian if they want to, if they see so fit. It's just plain and simple. I don't know what the heck the whole ruckus is about. As far as buying jewelry in vast quantities and things like that, I don't know anything about that. My concern is fine arts. I'm an artist, and if I have to be judged up here for speaking what's in my heart for my Indian people, and people don't want to be my friends, I don't need them. Galleries don't want to handle my art, I don't need them. In fact, they probably don't have any of my artwork in their galleries anyway. That's all I have to say.
Thank you very much. The next speaker is Charles Gord, who is a consultant, is current and was formerly the director of the Oklahoma Indian Affairs Commission. Dr. Gordon.
Thank you, Senator. And again, I wish to express my appreciation for the opportunity and our visitors from Washington. This is a crucial issue, obviously, all of us. I'd like to kind of approach it from a little different perspective than a lot of what we've heard. My concern in working with tribes while I was with the state, and Director Hart, you did a very commendable job, and I really appreciated your comments, is the nature of the government-to-government relationship, both within the state of Oklahoma and between the respective tribes and the federal government. We're talking here of a basic constitutional right, not only of the Indian tribes to determine their own membership, that is, who is and who is not a member, but it's the same sovereignty issue that affects the United States government and the U.S. Constitution, which defines membership and the rules and regs and the criteria to become a citizen. So it's a citizenship issue. Since Indian people are the only ones referenced by name in the United States Constitution, we have, as Ms. Cravens pointed out, a political and a legal status. It is not, as is most commonly misunderstood and presented, it's not a racial issue. And that's very important when one starts talking about the legal implications of what's involved in this act as far as civil and criminal penalties and fines and imprisonment. The key to this issue, from the point of view, is going to be the rules and regulations which have yet to be adopted, to be written by the Arts and Crafts Board. That's where they're going to fine-tune this bill. I see a number of problems and issues which those who are the leaders of federally recognized tribes, I call upon the leadership of the state of Oklahoma, Senator Haney and others, to support the efforts of federally recognized tribes to strike the provisions in here talking about state recognized tribes. It's, to me, is patently unconstitutional because of the Commerce Clause, which reserves to the federal government the sole and exclusive jurisdiction to deal with tribes. The only way to change that is the same process to change a tribal membership criteria, and that's to adopt an amendment to the United States Constitution to change that. And that is going to be a very important issue, and to me, this is the most damaging aspect of this law. While I was with the state, I had the opportunity to participate in a number of national conferences and conventions, and an organization in particular which I assure you is a direct result of the attempts and efforts in economic development by states from which the tribes in Oklahoma were summarily excluded to increase their tourism intake by a state recognizing a group as an Indian tribe. And they're rampant, they're thick, and there's a bunch of them, and they're making lots of money. This is to the detriment of the members of federally recognized tribes. I have a question as to why only Indian people can seek relief under this law. It seems to me if I purchased an item and it was later to be found out that it was not in fact Indian made, then what we're creating is a special category of person, which to me violates the due process and equal protection provisions of the U.S. Constitution. And as a reader and a participant in other federal agencies, what's going to happen when a federal agency, as the Administration of Native Americans, funds a non-federally recognized tribe, and one of the projects in there is arts and crafts to regenerate their heritage? Can another federally recognized tribe sue another federal agency under provisions of this bill? It's just something I would offer. Thank you.
Thank you. Our next speaker is Chief Jerry Haney of the Seminole Nation.
I want to say thank you to the State Arts Council and also to Senator Haney for allowing us this time to address this act. Well, I have not gone totally through reading the act. From what I hear, it's my understanding that the act provides for establishment of trademarks of genuineness and quality for Indian products, and to develop regulations and set standards. Because these regulations will be very important, I believe tribes should have a hand in the development of any such regulations governing the genuineness and quality of arts and crafts that will be permitted to be sold as Indian art. The definition of Indian should be of particular interest. It is incumbent on tribes to determine who is a tribal member and to make a register of the people so qualified. Skills and abilities, blood quantum, proof of some Indian ancestry can be used to qualify someone as an Indian artist. In a time when some Indians feel that our sovereignty is being threatened, we need to protect that sovereignty and be able to determine our own tribal membership and to identify our Indian artists. The law also recognizes, for the purpose of the act, state-recognized tribes. I have some concern that depending on how the regulations are drafted, the phrase recognized as an Indian tribe by a state legislature could be interpreted to mean simply a non-profit organization which identifies itself as an Indian tribal organization. This would permit significant undermining of the intent of the act if not clarified by regulation. In the Seminole Nation, we have some of the finest artists in the world that are enrolled, and we want to protect their work as truly Indian art. Mado.
Thank you. Chief Haney's my uncle. I paid him for part of that speech. That part about the great artist. The next speaker is Colinda Guthrie, who's a student at Tahlequah.
I'm Colinda Guthrie from Tahlequah, Oklahoma. I'm a member of the Cherokee Nation, and art is my career goal. This new law affecting Indian art will have an impact on me, my career, and my tribe for the rest of my life. Without this law, I may have to compete with children and grandchildren of non-member artists who claim to be Cherokees. I have been a member of the Cherokee Nation since I was 6 years old. Both of my parents are members of the Cherokee tribe. My family has always been Cherokee and always will be. I am authentic, not generic. In Tahlequah, the capital of Cherokee Nation, the children of our tribe are being taught about the art and the careers of non-member artists. What is common knowledge among the tribe that they are not Indians. The children in our tribe should not be force-fed false information. We should learn about the great artists who are members of our tribe. I and other young members of the Cherokee tribe boycotted an art contest because the judge was one of the non-member artists. Those artists are not tribal, and I will not be judged by them. Who are they to say what is Indian art when they are merely so-called Indians, not the real thing? The 1990 Indian art law is a good one, as long as there is no certification process for the non-members. This unfair competition will hinder me and my Indian art career and prevent me from being a successful contributing member of the tribal society and society at large. The non-member artists and their fake art are endangering my career and the career of members of other tribes throughout the nation.
Thank you. The next speaker is David Cornsilk, genealogist and member of the Cherokee Nation from Tahlequah.
Senator Haney, wherever you are, thank you for having this. Betty, I thank you also. I thank the folks from Washington, Kimberly, Jeff. I made some notes as I was listening to some of the folks. I have a 4-page speech that would probably last about 10 minutes if I read it to you. But the notes that I've made concerning the information that has been given already, I think, bring up some important points. I agree with Leilani Stone that there were no hearings in Oklahoma. An injustice has been done to the Indian people of Oklahoma because we have not been consulted on this law. Fortunately for us, though, the law does help the Indian people. The members of the tribe in Oklahoma are the only Indians in this state. The tribe has the sole jurisdiction over the membership and determining who is an Indian. It's not a matter of carrying a government card or even of Indian art. It's a matter of the self-determination of the tribes. There are 2 problems with this law. One was mentioned by Kimberly, which is the exemption of the state tribes, which I find to be unconstitutional, and I think the courts will find that so at a later date. The certified Indian artisans is also, I believe, to be unconstitutional. What separates them from the state-recognized tribes is simply that they are individuals rather than groups, but they are being recognized solely on the basis of their race, not on their relationship to the tribe or on the tribe's relationship to Congress. Under the authority of the Santa Clara versus Martinez Act, or court case, the tribes proved that they had the right to determine whom they will associate with and whom they will disassociate themselves from. If we choose to say that people of Cherokee descent, if any of these people actually are not of us, then who are the non-Indians, the gallery owners, to question us? We have the sole right to determine who is Cherokee and no one else. The certification process in this law is an intention of Congress to circumvent tribal law and allow for the certification of people by race, which is repugnant to the federal Constitution. We are Indians, that is true, but we are tribal people who just happen to be Indians who share in the government-to-government relationship. We could have been Martians when the non-Indians arrived here, and we would still have that same relationship. The talks given by some of the gallery owners speak to me of dollars and cents. It's the gasps of people who are trying desperately to save themselves from financial ruin. Turn to the tribal people. There are artists in the communities who do very fine art, beautiful art, but it has been pushed aside by the non-member artists. The self-determination of the tribes is the most important point that we can make here, and membership is key to that self-determination. The identification of non-member artists under this law is simply an identification by race and cannot be tolerated in this country. Thank you.
Thank you very much. The next speaker is Arthur Silberman, who is the Director of Native American Reference Library in Oklahoma City.
I did not come prepared to make an address. My remarks are in the form of a written question. There's no question that this bill has implications and consequences that are quite serious. Many of these concerns have been expressed eloquently and, yes, passionately by many of the former speakers. And it does indeed involve even agonizing decisions. I'm concerned, since my interest is mainly in Native American fine art painting, in some of the consequences and implications. I'm in trepidation of anything that casts a pall upon the appreciation, the recognition, the credibility, the integrity of all the art, and particularly the art of great artists of the past, because without an appreciation, without it being in our general consciousness of the society that this is a worthwhile art, worthwhile to research, to study, to appreciate, to collect, to display in museums, then it will impact upon the current activity of artists painting today. Artists painting today are standing on the shoulders of those of the past. So let me get to my question, which was originally addressed to Mr. Stamm. Please clarify how the Indian Arts and Crafts Bill of 1990 affects paintings by deceased Native American artists offered for sale by galleries, private collectors, and museums. Paintings for which a clarification of status is needed, and these include such things as unsigned 19th century ledger drawings, other 19th century ledger drawings bearing artists' names, but for which there is no biographical information or definite tribal attribution. Early to mid-20th century paintings by relatively obscure artists about which little is known, and finally deceased artists of all periods who were generally recognized as Native Americans, although they were not enrolled by any tribe. Thank you.
Thank you, Mr. Silverman. The next speaker is Linda Griever, who is the owner of the Art Market in Tulsa.
As the owner of a quote, unquote, American Indian Art Gallery, I would like to voice some of my concerns and recommendations on Public Law 101-644. Some questions about how to comply with the law as it is now in effect. How can I ascertain who is actually an American Indian? I understand that each person must be a member of a tribe. However, every tribe being sovereign has different methods of authorizing membership. Can I feel safe accepting cards, letters, numbers, CDIB cards, census numbers, etc.? Since this is a requirement, there must be a published list stating what is official from each and every Indian tribe. If a person misrepresents himself to a gallery, who is responsible? Is it the artist, or is it the gallery, or is it both? Can a gallery advertise and represent itself as an American Indian Art Gallery if the subject matter is Indian but not 100% of the artists are tribal members? Is a disclaimer stating that the gallery does not certify anyone's heritage enough to make the gallery in compliance with the law? How can work by deceased artists be sold when they are not around to supply the necessary information? It would be virtually impossible to research tribal membership of each and every artist represented in a gallery. I do not think that the repercussions from this bill are what its authors intended. I believe that when President Bush signed this bill, he was trying to keep out the Mexican rugs and the Oriental beadwork that was being passed off as Native American. Certainly, every one of us would agree with this. I do not feel that the purpose of this bill was intended to punish the descendants of American Indians who did not sign rolls, whatever the reason might have been. I would like to see the bill amended to include a grandfather clause, allowing artists that have been known either by reputation or through participation in competitive art shows to still be considered American Indian. Since we are trying to encourage quality in the arts, as well as to help Indian artists maintain economic independence, this grandfather clause would allow acceptance of living and dead artists who can reasonably prove their Indian heritage by genealogical records or by oral tradition, even if they do not appear to be on a tribal roll. As a gallery owner, I would like to be able to work with artists on tribal rolls without conflict. I would also like to be able to represent the work of artists that were entering shows and struggling to make a living as an American Indian artist long before this was the popular thing to be, without having to worry about my being fined and or imprisoned. I would also like to go on about my business without having to ask for verification of someone's heritage and to accept or reject his artwork for that reason rather than whether the artwork can stand on its own. In conclusion, I would like to see the import laws enforced and a grandfather clause in effect. But most important, I would like to see the true purpose of this law draw Native Americans into a unified community of artists rather than taking sides against each other and destroying an industry with a promising future.
Our next and last speaker is Ruth Blaylock Jones, who is the art director at Bacone College in Muskogee.
May I preface my remarks
Pick up your mic, please. Thank you.
May I preface my remarks by speaking anecdotally? In the overall scheme of things, in the Mideast situation today, in the nations perhaps on the brink of war, homeless Americans, even in our own Bacone community, we've recently suffered a devastating fire and also some deaths in our community family. In this reference, the Indian Arts and Crafts Law does not seem important. And these are the types of things that I argue with myself as I drive from place to place. And being Gemini, I think I'm entitled to do that. But some people have mentioned the fact that race is not a part of this, and it's difficult for me to separate because just this morning I went into a very nice
I have no questions for Mr. Stames or Cravens. I just wanted to say that I agree with the law, that it does need to have the support of the Indian people, especially the tribes, to get their memberships in order, because as a lot of people say, you're Indian as long as you believe you're Indian, and you can prove it to your tribal members. But if you can't prove to the tribal members themselves that you're a member of the tribe you say you are, then they say, ha ha, you're just another immigrant that came over on the boat. Thank you.
Is Charles Wells here? Charles?
I have a problem. I talked to the lady up front just a little bit ago, and she said that there would be 2 rows if the tribe would agree to it. One for the artisans and one for the tribal member. Well, most tribes' roles are already closed and won't be opened again because of fires and everything else. what happens there? Do we have a tribe, or do the Bureau of Indian Affairs come in and say, we're going to require that you make an additional row for these artisans that are not tribal members?
It wouldn't necessarily be a role that we're talking about. It's some kind of a certification. I mean, and when you have then a lot of people that are certified as Indian artists, then you probably have a list. And if you want to call that a role, then, I mean, it's a matter of semantics. This is just another, it's a window of opportunity for those people who are not enrolled Indians to be eligible to be certified as Indian artisans. It's not a new really enrollment list. It's its own hybrid animal.
Yep, it's actually up to the tribe.
It is up to each and every tribe to determine their certification process, what will constitute an Indian artisan to them, how they want to go about doing it.
So it's governed by the tribe. So if the tribe says, we don't want you as an Indian, that's it.
Okay, well, if you're at that point in time where you're not an enrolled Indian of the tribe, and then they say, no, we're not going to accept you as an Indian artisan, I guess that's kind of the bottom line right there. You've not jumped through two hurdles, I guess. But it is really up to each tribe. And we did that because we found that to be the most constitutional way. And that is in line, I don't know if you heard my speech earlier, with the Santa Clara Pueblo versus Martinez case, which went all the way to the Supreme Court. And the Supreme Court said, in essence, it's up to each tribe to determine their membership.
Thank you.
So for the purposes of this act only, this creates that tribal artisan.
Let me ask a follow-up question. Does the law require tribal governments to establish these structures within tribal governments to certify Indian artisans?
No, it doesn't require them. So if the tribe doesn't want to do it, then they don't have to do it either. It's up to the tribe.
Let me ask another question. It does not include, in the language of the bill, does not provide for a certificate of degree of Indian blood. Although most of us who use services of one type have, I mean, I've got a wallet full of cards, but
from how many different tribes?
as many as let me in. Now, but does a certificate of degree of Indian blood, does that card qualify you to be considered an Indian? Because it does not say that in the statute.
No, that may be something that a tribe will take into account, but that could be one of the things. I mean, the certification process is up to the tribe to develop, and they can use whatever documentation they want, or it could be totally oral history. It could be that you're a Navajo person who was adopted out by non-Indians long before the Indian Child Welfare Act was passed, who, you know, you have maybe were never raised around Indians, but, you know, I mean, it's really going to be up to the tribes, and they can determine how they want to work this.
So the statement that was made earlier in reference to having one standard for those who qualify as certified Indian artisans across the country is not necessarily true, because each of the tribes can and probably will establish their own criteria.
Correct. It's up to every tribe to determine how they're going to work this thing. And so we wrote a letter to Secretary Lujan encouraging him to work, or to provide resources to the Indian Arts and Crafts Board to work with the tribes in a dialogue process or a consultation process to talk to the tribes about how they want to work this, what they may take into consideration, you know. Because I think that the tribes are going to be rational about this, that they're going to take other things into account besides just a blood degree card or whatever. You know, they may want to open their arms and claim everybody, you know, and then there may be some that don't.
Okay, we'll go to the next question. Merv Jacobs.
Can I say one other
Sure.
thing? That we do have a provision in here that tribes cannot collect a fee for this thing.
It says it may not collect a fee.
Yeah, they're forbidden to collect fees for this. They cannot collect fees.
But as a general rule, and I say may not in statutes, it does not prohibit them from.
They are prohibited from collecting fees for this. That is what, they cannot collect fees for this.
Okay. Is Merv Jacobs here? Okay. Thank you. S.S. Burris?
I contend that this law cannot be implemented by the Indian Arts and Crafts Boards because, one, they would have to define arts and crafts, and then its definition restrict art, which is innovative and creative and thus be censorship. Two, they would have to define Indian and could do only this if the Indian nations were consistent, which they are not, so this would be discriminatory. Thus, the purpose of this law to protect the public against fraudulent Indians and crafts puts the burden upon the Indian, which is unfair to the Indian. Since it cannot be implemented and executed in a fair and equal manner, keeping the integrity of the Indian tribe and the integrity of the citizenship of the United States, this law must be eliminated, removed, and eradicated. Use the monies to educate instead of justifying this law. This can be the tool to prevent fraud. They always say that the buyer beware. Educate your buyer. Quit putting this burden to cause a rift in the sovereignty of the Indian nation. Thank you.
I think it's going to be difficult for the panelists to respond to statements. If you would just submit those statements to us, if you support it or don't, that's fine. But I think if you could ask, if you have specific questions that you need answered, that's the time to do it now. And we have the people here. We don't have much time, but if you could do that, I would appreciate it very much. Sandra Peters.
I find it incredulous that 17 people have gotten together and caused so much commotion, over several thousand. My question is, this bill will never fly before the Supreme Court. No way, no how. Have you thought of this? And tell us what you have come upon with your information from Washington and the passage of this bill and the legislators and the lawyers and the cost of the implementation of this bill.
Could you be more specific about what you think is unconstitutional, please?
Because it is against the race. There is no law that says that a white person has to have a lineage or inheritance or heritage background, nor black, nor Hispanic, nor Chinese, in order to sell their work. There is no gallery in the United States that has to have, that is a law, except until now, carry Indian work. That is
thank
my...
you. Would you, would either one of the panelists like to respond to that, please?
Mr. Sam.
My only response is I don't see that the law is unconstitutional in any way. I'm not a constitutional lawyer, but the law does not prohibit you from marketing any kind of work. The law it says that whatever you sell, you must represent it correctly. Practically every state in the country, in fact, it's the Uniform Commercial Code, has a law that makes it a crime to falsely advertise goods. This law is no different than laws like that. It says if you want to market your work as Indian art, then you better be an Indian.
Okay, thank you. Is there, let me give you three people here in this order, and we'll be concluding here pretty quick. April Perry from Dale City, Eula Dunking, and Steve Kerr. Is April here? All right, Eula, would you ask your questions, please? I said that because Eula had a whole speech written out here, and I asked her to ask her questions.
Well, I do have my. Is this working? I do have my speech written out. I am Eula Dunkeen. I'm a Seminole Indian, full blood. I'm an artist and craftsperson. I'm going to preface my question by this. I've observed for years and years the non-Indian elbowing and pushing his way into Indian arts and crafts shows, galleries, and museums, and thereby pushing the real Indian artist aside. And we stand and wait in line, trying to look in and see what's going on, even though we've presented our credentials. Now that has happened so many times. I too have been pushed aside. But my question is this: is there a danger that a non-Indian could be certified by an Indian tribe to be an Indian artist? Because my question is this: because I'm a proud possessor of a tribal enrollment card, CDIB card, and most galleries ask for my CDIB card, but they don't ask the non-Indian. The non-Indian gets in, and here I'm having to make copies and submit them. So I want to know if there's a danger that a non-Indian can be certified as an Indian artist, thereby still pushing us back.
Either party can answer.
Well, I suppose it's a theoretical possibility. Certainly the intent of the law would be to answer you no, but it's going to be up to the tribes to decide whether a particular individual meets their certification standards or not. Certainly the law does not contemplate that a Hopi, the Hopi tribe in Arizona would simply take someone who walks in from New York and say, okay, bango, you're an Indian artist, we recognize you. The tribes have more integrity than that. I think someone will have to prove some kind of ancestry to the Hopi tribe in that situation. As to what criteria the Hopis would accept, it's going to be up to them. Certainly, it is possible that someone could fool a tribe with false documents or whatever it might be.
Do you have a follow-up question?
Yes, I have one other question. I have asked to see several people's CDIB cards because they say, I'm Indian. I said, let me see your CDIB card. I have no qualms about that. And sometimes they show me a card that says they're 1/64th Cherokee. Okay, that's what I'm talking about too.
Well, in this case, the law says nothing about blood. Blood quantum is irrelevant for the purposes of this law.
That's what we all need to know. Thank you.
It's strictly a matter of who the tribe accepts.
Okay, Steve Kerr. Steve here. Yes,
Could I say,
I'm sorry. Go ahead.
Indians are given special services not because they're a racial group, it's because of their political status. The government-to-government relationship that's based on treaties and a historical relationship with the United States government. That is why we have passed many laws, numerous laws about American Indians and tribes to benefit them, and why this law is constitutional as opposed to a racial-based law. We can't pay, that's why we have these problems with the Department of Education and the minority scholarship money. That's a racial thing. This law, the 1935 law, and all the other laws that we passed for American Indians are based on that government-to-government relationship.
Thank you. Mr. Kerr.
Senator. My name's Steve Kerr, and I'm a trustee of the Kerr Foundation, which is a charitable trust based here in Oklahoma City. I think I'm speaking for many charitable trusts probably across the United States when I pose this question to you. And it's based on the scenario that my foundation, or I say the foundation that I sit on, sponsors many Native American activities and art and artistic events. Would the foundation be placing itself in a civilly liable position if it sponsors one of these artistic events, and a non-Indian, underneath this act, artist places their art in a fraudulent manner in this event, would we be civilly liable? Is that something that that this addresses? And I know you say that, especially in the criminal, that you have to have evidence, but anyone can file a lawsuit. I am an attorney. I'm not familiar with Indian law. However, I do know that anyone can walk into any courthouse and plop down a lawsuit. That's our right in our system. And even one lawsuit, which is not successful, can place a pall over the support that foundations such as the one that I sit upon give to the Native American artistic community.
I don't have a perfect answer for you because I'm just not an attorney. I don't know to what extent your reach is. But let me turn that around and ask you a question. If your foundation were to fund some project that resulted in air pollution, do you feel that you're civilly liable for the air pollution that takes place? I mean, generally, foundations are removed from the actions that they fund. No, as I said, generally. Secondly, I would also remind you as to who can bring a civil suit. There are only two parties under this law who can bring a civil suit: the Attorney General of the United States or an Indian tribe. That's very limited.
Let me ask a question almost relevant to perhaps what he's saying, or at least connected. Part of the language of the statutes defines the term Indian Arts and Craft Organization means legally established arts and crafts marketing organization composed of members of Indian tribe. My question is, must all members of this organization be Indian, or is it just 1 out of 10 or 8 out of 10? Because there are a number of Indian arts and crafts organizations who attempt to market art. They may not all be Indian people on that board. What is your interpretation of that portion?
I think the attorneys have to continue to look at it, but my opinion is that the law clearly contemplates that the membership of an organization be overwhelmingly Indian. If you had an organization of 100 members and 99 of them were Indian, but you had one non-Indian, does that disqualify you? I don't know. Honestly, I don't know. I think you'd have to look at the circumstances. But certainly, I think the intent of the law is clear. We're talking about Indian organizations.
Let me perhaps conclude at this point. I apologize that we brought you to this point and we're not able to pursue it, but we have been in the chamber much longer than was granted to us. There are a number of other questions that that other members have. You have the names of the people that are here, and we just simply ask that you be in contact with these people. If you would like to work through the State Arts Council, I'm sure we'd be happy to work with you. Thank you very much.
Sure. Hope it's. Oh, good. That's correct.
With the bill that you currently have, the bill that you currently have in your possession is the Federal Indian Arts and Crafts Act of 1990, which is a federal act. That is the issue we're talking about. I also stated to you that there was an Oklahoma statute on the prohibiting of the sale of Indian-made products, and I have a copy of that bill. Mr. Jackson will be in the front of the chamber if you would like a copy of this, but please do not confuse this with the bill we're talking about. This is the current law under the state of Oklahoma.